the end of leasehold ? Are we about to see the end of leasehold with the laws that are proposed, that are coming through?
It's cumbersome. It's really cumbersome and it's expensive. And the only people that benefit out of situations like that are the lawyers.
One of the things that worries me about the approach of what we're talking about is snap voting, replacing lots of existing protections that are in landlord and tenant law.
You've got everybody infighting. It's a lot easier to come together and unite against a common enemy, and that common enemy is likely to have other properties and deep pockets. But when you're fighting your neighbours and your only asset is the freehold building, that makes it a lot more difficult.
I do think that there are other things coming down the track, and probably coming down the track sooner, that is going to impact property managers quicker than what Commonhold is necessarily going to impact property managers.
What does the leasehold sector look like from your point of view, Cass? What are your predictions? What will we be talking about in 5 years' time? Hello and welcome to episode 3 of the Block Coach podcast. I'm Joe Allen, founder of the Block Coach. Today's episode is called The End of a Leasehold. We're going to look at leasehold reform, the push towards Commonhold, and what all this could mean for leaseholders, managing agents, resident directors, and the wider property sector. But before we get into the main discussion, this podcast is sponsored by a Head Start Consulting. A Head Start Consulting is redefining what smart, practical safety support looks like across the built environment. As specialists in health and safety, fire safety, and full spectrum building safety compliance, they help commercial organizations, big and small, including managing agents, property owners, private international developers, and resident-led organizations to cut through complexity and stay confidently on the right side of the law. In short, a head start are the people who voluntarily read regulations, understand them, and even enjoy them so that others don't have to. Risk assessments, compliance audits, training, strategic support, and guidance. Yes, they do all that. A Head Start Consulting, practical, grounded advice, commercial awareness, and the confidence that your buildings and the people who live, work, shop, meet, or occasionally get lost in them are protected using actual intelligence, not just artificial intelligence. Now, back to leasehold. Leasehold has been part of the property system in England and Wales for a very long time. It is old, complicated, often misunderstood, and increasingly under pressure. For some people, it is a system that can still work if properly reformed. For others, it is a system that has had its day. With me today are Ellodie Gibbons of Landmark Chambers and Cassandra Zanelli of PM Legal Services. I'm delighted to have them with me today. They are two experts in their field, and I'm looking forward to getting stuck into this subject. Hi, so like I said, today with me, I'm delighted to have two very special guests, Ellodie Gibbons of Landmark Chambers and Cassandra Zanelli of Property Management Legal Services. Welcome to the Block Coach podcast.
Thank you.
Thank you.
We're going to kick things off getting to know our guests because, as I said before, people are going to want to know about your story, Cass, and about your story. So starting with you, Ellodie, how did you get into law and how did you find yourself in leasehold?
So I suppose I got into law slightly by accident because I ran out of other subjects to study that I was interested in. I wanted to be a managing director of a multinational, or CEO of a multinational, the university, but they didn't advertise those jobs on the milk round. So I decided to be a barrister instead because I could be my own boss from day one. And I started out because the work that was available when I was a pupil and a very junior tenant was possession hearings, largely for local authorities, housing associations, dealing with short life, assured short hold, secure tenancies, etc. And that developed into leasehold. So the housing associations that were giving me their short life tenancy work started to give me their leasehold work, and I started off dealing with service charges, etc. in the first tier tribunal, and it's just gone on from there. And then in, I think it was 2009, 2010, I ended up writing a book on enfranchisement, largely because there was no one else in Chambers who wanted to write it. Mm-hmm. And that's how I I was already doing that sort of work at the time, but obviously over time, various things have happened to develop that specialty. And then, more recently going to work for the Law Commission and working on the leasehold reform project.
Okay. I did not know about that earlier ambition of yours. And can you just share a little bit more with us?
What, to be CEO of a multinational?
Yeah, that one. Yeah.
I just like being in charge. But as I say, yes, I kind of thought that actually, I would go and be a barrister, and if I liked it, I'd stay. If I didn't, I'd move out and do something else. And thought it would be easier actually than doing it the other way around and training to be a barrister later on. Although you come to be a barrister and realise that you've not necessarily got the transferable skills because you don't manage anyone, you don't work as part of a team, and what you're basically doing is arguing in court. So there's not necessarily a huge demand for that in other roles.
So I'm assuming that you went to uni, right? And you did a law degree
I
straight
did.
away.
Yes,
Yeah,
and
okay.
I think if I had my time again, I'd perhaps do something different. If I'd known I was going to be in the law for the rest of my career, I'd have perhaps chosen something different. But as I say, at the time, I'd done sort of other social sciences at A-level, and the law seemed more interesting at that point than economics, for example.
Okay. And what about you, Cass? So, another lawyer, another person from the legal world. We've known each other a long time, and I do know pieces of the story. But like Ellodie, there's things that get found out of this podcast.
Yeah, I'm
What about
about to age myself in
Really?
one sentence. So the reason that I wanted to be a lawyer, and I've always wanted to be a lawyer, is, and please don't judge me, I watched LA Law as a child.
I thought you were going to say Perry Mason.
I feel like there's a distant memory of you saying that at some point. Elaborate on that, please.
The stock phrase I tend to use is that it was never like this on LA Law. LA Law lied to me, frankly. Not quite as glamorous as what they made it look like, but as a feisty 9-year-old watching LA Law on a Thursday
That is
night.
young.
Yeah, probably slightly too young to be watching LA Law at that age. But I did, and I really wanted to be like the characters on LA Law, so that's what I've always wanted to do, and became a solicitor as a result of that. Went through school, college, uni, studied law, did my postgrad, and then ended up somehow in property management law.
So everyone always talks about falling into. I mean, to be fair, that's a good get out from the usual. I fell into it by saying that I wanted to be a lawyer since I was 9.
I fell into property
But you
management
fell
side
into
of
property
things.
management, right? Okay.
Yeah,
How did
so
that
it's
happen?
really by accident. So I started when I left uni and finished postgrad, started paralegaling and was a criminal defence solicitor for a while. So did that for, gosh, I am aging myself now, 9.5 years. Then did regulatory law for a couple of years. And then, same as most people that end up in property management, fell into property management and loved it and have stuck around ever since.
Yeah, I seem to remember back in the day being an assistant property manager working with you, being a junior PM and actually learning a lot from you. So thanks for that. A lot of us guys who are not in the legal world don't understand and take ages to understand the barrister route and the solicitor route and why people go down those different avenues. Can you help us out with that?
We've only got 45 minutes, haven't we?
Ellodie takes all the glory, we do the work.
Oh.
We'll go with that.
So my understanding is that obviously the barristers make this sort of the case, the verbal case, right? The verbal case on things, but it's deeper than that, though, right? Because that's just what we see,
Yes, and the thing is, I mean, obviously it's the barristers who stand up and argue the case at the end of the day. It won't just be the verbal arguments, but there will be, a lot of written work that goes in before that. But then the thing is, what we have is a specialist knowledge, experience from doing that in order to be able to advise. So I think in terms of property management, a lot of the time what we're doing is advising people how not to end up in court. And the thing is, it's only when, you've had that court experience that you can say, well, this is what you should or shouldn't be doing in order to. But I mean, I often say that, it's not quite the same when we're talking about a specialist area like leasehold or property management. I say that it's a bit like your GP and your consultant. There's far more that the GP is doing that will never go anywhere near the barrister because it's much more day-to-day problems are going to the solicitors, and it's only when you need that specialist help, which is, say, could be litigation, but it could be how to avoid litigation or something along those lines. It's only when you need that you will then go to your consultant, the barrister, which that does makes barristers sound more important than solicitors. But I think they're sort of equally important roles. It's just using slightly different skill sets. And I know that, Cass will have to deal with clients face to face much more than I can filter a lot of what I do through solicitors. So I can be as rude as I like to the solicitor, and they will then filter what they pass back to the client.
So I remember we weren't even allowed to instruct barristers before the AIRPM, or the IRPM got involved and sort of made it so that MIRPM, now MTPIs, could contact you. Why is it that only some people can sort of reasonably instruct you guys? Like a solicitor could instruct a barrister, but for example, other professions are not even in a position to.
Well, a lot of it is money.
Yeah.
In that, as a barrister, we're all self-employed, and we want to make sure we get paid. And there are obviously a whole load of rules and regulations in place in terms of the relationship between barristers and solicitors, so that it's not worth a solicitor's while not to pay us for good reason. Whereas, if it's members of the public, I appreciate that's not necessarily managing agents, then we've not necessarily got the same protections in place.
Okay.
It's essentially, it's usually more efficient to go if you've got a good solicitor and a good barrister, it's usually more efficient to go through a solicitor, because the solicitor will filter out what it is that the barrister needs to see, what the questions are for the barrister. Sometimes it can, I do work directly with managing agents, and if there is a discrete inquiry that the managing agent is able to kind of put together, formulate the question, put together any relevant documents, then it may be quicker. But a lot of the time it will be more cost effective to go via a solicitor and have both working together.
That teamwork's important because we both bring different things to the table, don't we? Yeah. And those slightly different skill sets come together and get the best result.
Yeah.
I've heard it said that it's, the solicitor prepares the case and the barrister argues the case. And I think that's a far better summary of the two different skill sets there. Cass, why do you think that lawyers end up spending so much of their time in this complicated little area of the property world, leasehold?
I can only speak for myself and my own personal experience, but it's a really interesting area of law.
Yeah.
When I compare that to the other areas of law that I've done over the years, there's not a huge amount of statute here, although I know that there's a few of them, but compared to other areas, not as much.
Oh, really?
But there's a huge amount of case law. And it's the case law that you need to understand to then be able to advise and do whatever it is that you're doing for your client.
So when property managers are complaining that there's so much parliamentary change all the time and whinging and moaning about it, we're kind of whinging and moaning unnecessarily, are we?
There's a lot of change, but there's also a lot of case law that changes things far more often, I think, than statute changes. That said, there have been a lot of statutory changes over the recent years.
Yeah, that's why I always say to junior PMs, if you've got to keep an eye on the case law. You'll always see me. Obviously, I've been at both of your case law updates and always be there at the front. If there's anything that property managers are going to do at these conferences, be there for the case law updates, because it literally changes your day job from one case to another. The paper that you're having to fill out, or the form you're filling out, or the conversation that you're having is changing based on what happens on different rungs of the court ladder, right?
Yeah, and managing agents are always really open to changes, in my experience. That you want to know what's happened, you want to know what the impact is on you guys and your day jobs, and what you need to do to make it work.
Yeah. So why, guys, is leasehold so unpopular? Ellodie, we'll go back to you. Why is leasehold so unpopular with the public?
Yeah, in terms of sort of leasehold, and I think sort of the wider, is leasehold the problem? I don't necessarily think that's the case. But leasehold has become very, I wouldn't say more than unpopular, it's become quite toxic. And I think that we can say we wouldn't be where we are now if that wasn't for leasehold houses being sold leasehold when there was no need to sell them leasehold, and onerous ground rents. And essentially, both of those things have come about because it's been making a financial product out of people's homes. And obviously that's to do with economics, and that, other forms of investment have not been as good. So I think that that's why we've got leasehold in the spotlight, is because of those things. There are obviously other things things that now people are complaining about, and obviously it's brought into focus how leasehold is a wasting asset, etc., etc. Those things have always been there. I don't think we've ever had quite the momentum for change that we have at the moment previously.
What do you think, Cass?
I think it's the complexity of leasehold. We were talking about this earlier, and another well-known barrister in this area of law says that leasehold is a bit like a magic spell book, where only certain lawyers know where the spells are and the impact that one spell might have on another spell, which probably goes back to the case law point I made a couple of minutes ago. But that, to an outsider, to a leaseholder who has bought a flat in this block of flats,
Yeah.
that's incredibly difficult to negotiate and to understand and to apply to their specific circumstances. That, I think, is the unfortunate thing about this area.
And how would you contrast that with other property ownership forms? I mean, from around the world and Commonhold. What makes these, the other forms of ownership simpler than in blocks of flats, from your point of view? Why is leasehold so complicated? Is it really so complicated?
Do you think it's more complicated than other areas or other jurisdictions?
I think it's just that the honest truth is that I don't know a lot about what's going on around the world. I guess it's one of those things, you grew up with it. My first property was a leasehold property. Just didn't really think anything other than that's just how it worked, right? But I suppose it goes all the way back to the feudal era, and before the Law of Property Act came along in 1925, you had all sorts of weird and wonderful forms of ownership, didn't you? And it seems to be a relic, doesn't it, I suppose, of those times. I guess when you've just grown up with it and that's all you know, perhaps you underestimate the complexity. But I guess for a person coming into to buy their first home, I suppose there is a case for it being a little bit complicated.
Yeah, and I wonder whether we're doing people a disservice sometimes by not helping them understand.
Yeah.
You rent a property, you get a how to rent guide. Why aren't we giving out a how to lease guide when somebody buys a leasehold property?
Yeah.
Why aren't we telling kids about it in school?
I was going to say we could go even further back than the point at which you're buying, actually educating people about, growing up, I had no idea that, how flats worked or about tenure or any of those sorts of things. So that, if it wasn't for being a lawyer, I probably wouldn't have had much of a clue when I went to buy a flat. I mean, I used to say, my parents don't understand what I do because the village in which they live, there are no flats. I mean, then years later, I got instructed on development. It turns out that's at the bottom of the village. So I had to eat my word. But the thing is, it just wasn't. And because in some areas of the country as well, there just isn't the prevalence of flats. There isn't a need for it. And so people don't necessarily understand. But I think probably a better understanding of the law as a whole wouldn't be a bad thing to be taught in schools, from a relatively early age.
Yeah, I think a lot of professions are often banging the drum, aren't they, for their area of the world to be taught in schools, aren't they? Often hear and say it should be taught in school, but I do think there's a genuine case for this being taught in school. I mean, it is the biggest investment most people ever make, right? It's your home, the home, and invariably there's not that much space in the UK that people are going to have to live in communal blocks of flats, right? They're going to have to get used to communal living at some stage. Now I had to. I do think flat ownership is getting a bit of a kicking at the moment, to the point that it's become a bit strange, though. I kind of feel like, my first property was a leasehold flat. The service charge was reasonable. It was a simple estate. It was a simple estate with, in a simple block, and it worked quite well for me. And when the time was right, I moved into a house, and that's how it's supposed to work for lots of people, isn't it? Had a kid, got fed up of not having a garden, and we moved into a house. But I tell you what, since moving into that house, within minutes, we realised that the boiler was kaput. 2,500. That was more than my annual service charge in my flat. And it's on me. There's no economies of scale. There's no shared costs.
But at the same time, it's on you to make the decision as to how you repair that boiler, when you repair that boiler. I mean, I have a freehold house where I had a cyclist go through the front window. Wasn't pretty for either the window or the cyclist. I could have made a claim on my insurance. I decided not to. I'm going to put up the insurance premium, I'm going to pay an excess. And actually, I think those windows, they needed replacing anyway. So I, make that decision. And then I say, well, actually, you know what, I can put up with a boarded window for a bit because the time and hassle it takes for me to find someone to replace all these windows, pay, etc. I can put up with a bit of a boarded window. And then when I have the window replaced, I choose to replace it in softwood rather than hardwood because I think I'm not going to own that property, long enough to get the benefit of the hardwood windows. So all of those decisions as a freehold owner, I can make on my own. And the problem with having a flat, and it doesn't matter whether it's held leasehold or commonhold, is that you've got to take into account the circumstances of lots of different people. And it doesn't matter how much regulation we put in there, you're still going to have that community living. And we're talking about, early education about the law, but then perhaps one of the other things is actually educating about community living and the fact that, especially if, you say you bought a flat, you get a house, you've got a kid, once your child grows up, they've grown up with a freehold house. They're not necessarily going to understand what it was like for community living. And so I think that is at the heart, I think, of a lot of the issues with leasehold is community living, which is not a problem with leasehold itself, it's the problem with community living.
Absolutely. Well, there's the community living piece, and I think people living in a block have to understand that if you have a flat, a lot of whatever system we come up with, there's going to be theoretical, imaginary, if you like, man-made structures that don't physically exist, that are dividing these units from each other, right? And whatever way you knock it up, communal living is something we've got to crack. But I think you touched on something there, and I'm quite interested to get Cass's view on it, Ellodie, and that's and I think it's about control. Really, is control a big reason why leasehold is so unpopular? Because obviously, what I read a lot of is, we've got our two types of leasehold blocks currently. In my view, we've got the homeowner control blocks, and we've got the landlord control blocks. And to me, it seems those in landlord control blocks, or the law is trying to change things because of what lawmakers see happening in landlord control blocks. Is that about right? Would you say?
Yeah, I think it's the power imbalance.
Yeah.
If you look back at Labour manifesto, they talked about that power imbalance and bringing measures into place to address that power imbalance, and which is what we have with a lot of the LAFRA reforms.
Yeah.
Take the transparency provision, so the leaseholder protections piece around that, the need to produce accounts, the need to have your budgets, your standard form service charge demand, your standard form or newfangled equivalent of 20B2 notice, the whole piece around publishing admin fees and replying to inquiries, those sales information packs, that is designed, in my view, to address that power imbalance that exists at the moment. Which I think is part of the problem as well. Yeah,
and the proposed solution on the table is Commonhold, right? It's moving towards a place where, from my point of view, it's bringing everyone into line with the RMC, RTM decision making style. Well, from the manager's point of view, it's democratic decision making to increase control, right? That's the direction we're headed in. And the question and the title of this podcast is, the end of leasehold ? Are we about to see the end of leasehold with the laws that are proposed, that are coming through?
No.
No. Well, why'd you say no?
Well, I mean, obviously what's proposed at the moment in the draft Commonhold and Leasehold Reform Bill is banning the sale of new leasehold flats. So we're going to have the existing leasehold flats are going to remain in existence. Yes, it is possible to enfranchise, and it is going to be possible or made easier to enfranchise and then convert to Commonhold. But essentially what is happening is an increase in consumer choice, because as much as I think there are those people who want to take control, perhaps because they've had a bad experience, their landlord isn't necessarily managing the block as how they want, there are other people who actually would sooner just hand over responsibility for all of that to somebody else, where you've got a good landlord who's managing well, that it is far easier to get on with your day job and let somebody else run the building. And for some people, flats are actually really attractive, because rather than that freehold property that when the boiler packs up, they're solely responsible for, if you're in a flat, it's often easier if you've got a good landlord to be able to phone up someone and say, I've got a leak, or I've got the boiler, something's gone wrong, and get someone else to deal with it. So I think we're not looking at the end of leasehold. What we're looking at is greater consumer choice. Obviously, the proposal is to end leasehold in terms of most new build flats, but it's going to be a long time before you necessarily get rid of all those existing leasehold flats. And also, that's only going to happen if people actually want that to happen.
So as advisors, starting with UCAS, so you're not worried about suddenly becoming redundant then with a new form of ownership coming in. Is it the opposite?
No, I'm comfortable, Joe. I'm comfortable that I will have sufficient work coming in until I retire, whether that be leasehold work or Commonhold work, or frankly, still the onslaught of building safety.
So let's talk a little bit about Commonhold then, as to what it is. And sorry to pick on you guys, but it'd be good to sort of get your assessment. How would you summarise in the shortest possible way what is Commonhold? Ellodie, what is Commonhold?
I was going to pass it over to Cass first. What is Commonhold?
Well, listen, you argue the cases in court, and you've got to be succinct when you stand in front of the judge. That's my understanding, so that's why I picked on you.
I'm regularly told by colleagues, Ellodie, we do not need to know what you have for breakfast. Just say how your day went. Anyway, Commonhold. Well, Commonhold is essentially giving each person a freehold or equivalent freehold ownership of their flat, so that we remove the layers, as in the freehold and leasehold layer, and everyone owns a Commonhold unit. So we've got these individually held, effectively freehold Commonhold flats, and then there is a Commonhold community, essentially, that and a Commonhold community statement that regulates how all those interact with each other, rather than the layers. So perhaps we can see it more as a sort of horizontal control rather than a vertical control in terms of the management of flats. How's that for succinct?
Pretty good. Pretty good. What would be the solicitor's view? Your turn to get your own back on the barristers getting all the glory.
I agree with the barrister.
I mean, the skeptic would say, what's the real difference between Commonhold and share of freehold, which already exists? Cass?
The control, the freehold ownership, rather than it being a wasting asset that diminishes with each new day that dawns.
Even with a 999-year lease?
It's the community and the control. That's important.
Is there more control in a Commonhold association than a share of freehold block, do you think?
Given the way that the decisions are made in Commonhold, yes, I would argue that there is, yeah.
So I think that's the bit that a lot of us are a bit unsure of, even in a managing agency world. So just maybe you can elaborate on that. How are the decisions made in a Commonhold association that are gonna bring about more flexibility? Because that's what the government say, isn't it, in their consultation, that basically existing freehold structures, even share of freehold RMCs, it's not flexible enough. Can you shed any light on that? Because I couldn't really glean much from what I read.
Take a lease, for example. Yeah. The leases that we have for our leasehold blocks at the moment might have been drafted 50 years ago.
Yeah.
And time has moved on in the last 50 years. So if we want to vary the terms of that lease to modernise it, bring it up to date, even something as simple as referring to EV charging, we're going to have to vary the terms of that lease.
Yeah.
So get everybody to agree to it, to register that deed of variation at Land Register. If we can't get 100% agreement, we're off to the tribunal, hoping that we can get 75% agreement and not less than 10% disagreement. It's cumbersome. It's really cumbersome, and it's expensive. And the only people that benefit out of situations like that are the lawyers.
Yep.
But with Commonhold, we have our Commonhold community statement.
Yeah.
That is set down by regulations. So one Commonhold block's Commonhold community statement, theoretically, identical to the Commonhold block down the road or in the next town, etc. And we vary our Commonhold community statement at local level to fit the way that we want to live and work as a community in that particular block by imposing or varying local rules.
Yeah,
much simpler, much more efficient.
Yeah.
Much easier, frankly.
As someone who would consider myself an RMC expert, because that's where how I built up my business over the years working with RMCs, I did get a lot of frustration that RMCs were being treated like landlords, basically, with legislation designed to restrict bad landlords, and it was really stopping communities that I was working with doing basic stuff like raising a reserve fund or basic things, because we were facing huge threshold or votes that were unworkable in a community, like 90% or more, to be able to vary leases, and the cost of doing that was extreme. So it was just prohibitive. And so are you saying that with the Commonhold model, it's going to be simpler and easier to do?
Absolutely.
And what are we talking about? A majority vote? Or are we talking about just a straight majority, like a 51% vote? Is that what we're talking about here?
I mean, bear in mind that we've got the draft bill and we're kind of
Yeah.
waiting for Commonhold Mark II and what that might look like. So
Okay, it's
but
interesting.
as it stands,
Yeah, that's, yeah. I mean, because definitely we've had issues with that where we had fairly sizable majorities unable to get things through.
Bear in mind as well that if there is something that the Commonhold Community Statement is prescribed by regulations.
Yeah.
Regulations are much easier to change rather than changing statutes. So if there's something that happens,
Yeah.
building safety crisis Mark II, whatever that might be, that causes government to need to change at source that Commonhold Community Statement, it introduces regulations to do that and address that.
Because I was going to say, you'll probably find with your, RMCs that the leases aren't necessarily drafted to take into account. Even, I mean, obviously sometimes developments are set up where there is a management company, but even the leases which follow a kind of old form of lease, you'll find that they don't provide, for example, for the RMC to recover its own internal costs of administration, which obviously there's provision for within, Commonhold Community Statement, within the Commonhold draft legislation. So things like that, it's that the leases aren't necessarily fit for purpose, and as Cass says, there isn't the flexibility. And in a lot of places, there isn't the consistency. So you've got different leases on different terms granted at different times, which makes it more complicated.
Yeah.
And I think, that's certainly what I've seen in blocks that I'm looking at now going, oh, might this be a candidate for Commonhold conversion? Because I'm looking at what's happened historically and the fact that, perhaps service charge percentages, which have been weighted favourably for, landlords' mates rather than not, that sort of thing. So I think the thing is, I mean, it is possible to standardise leases, but as Cass says, there is a lot more flexibility inherent in the Commonhold model.
Okay, that's some pretty good answers there. I mean, I've got two main problems with Commonhold. I don't think we've got time to go to all of them, frankly. I want to make one main point, just as someone who has had to be on the front line, the coalface over the years, in whipping up votes, for my RMC clients to get things done, and seeing how that plays out in practice. I think one of the things that worries me about the approach of what we're talking about is snap voting, replacing lots of existing protections that are in landlord and tenant law. And so I teach the TPI Section 20 course. So and actually, I happen to think, and a lot of people hate Section 20, I happen to think there's a good spirit in there. And that is, I don't always think that a snap vote is as in a dwelling holder's favour as much as a consultation. A consultation on a large project is going to cause a lot of disruption, cost a lot of money. A consultation is quite good for that, because what it does, it allows the average person who goes to work and works long hours and comes home, has to deal with the kids, it gives them a 35-day window in most cases, 30-day going by the statutory rules, to comment on each of the notices and have their say and have something to say about these huge plans for the building. Whereas I'm aware of somebody who has a flat in Scotland, and this is anecdotal, but she wasn't able to make a meeting about the roof replacement. Within a few days of the meeting, she received a bill that was payable within 14 days because of a snap vote taken about replacing the roof, and it was in excess of £10,000. And I worry that snap voting of just a simple majority of 51% of the people present, which could actually just be a fake majority of just like 3 people, showing up in a block of 10 flats, who've got the time to go to these things, because you've got to think about the sorts of people that go to these meetings have got time. They might be retired. I'm not trying to generalize, but sometimes they are. Whereas working families, shift workers, suddenly going to find themselves ruled by snap vote, in time, as opposed to this, more measured process, which is let's have a consultation, let it run for a period, so everyone gets to have their say. I'm a bit worried that is just one example of the protections that exist in landlord and tenant law in favour of dwelling holders. And people might find that in the new world of Commonhold, those, I guess you could call them minority rights, could be massively eroded, and actually you could have a situation where you're just being ruled by whoever's got the least time-consuming job to go and run that block.
But that's a problem with snap voting, not necessarily the system. And the thing is, in terms of your Commonhold community statement, and I think I'm right in saying there'll be provision in there that there has to be a reserve fund, for example. So, and that in terms of, and there will be provisions in there about how decisions are taken.
Yeah.
So that actually you can legislate or regulate against those sorts of things to create, in effect, the equivalent of Section 20.
Yeah.
Because I personally think that Section 20, a landlord goes through a Section 20 process. As long as they've ticked all the boxes, they can actually do what they like, ultimately as the costs are reasonably incurred. But then, there's more than one way of reasonably incurring costs. So I'm not sure that it necessarily genuinely provides the protections that people, because in a Section 20, people can express views, but they can't vote as to what ultimately happens.
Yeah.
Whereas actually, I think, as say, that the problems you're identifying are the problems with the way it's run rather than the system itself.
Yeah. Okay.
Have you responded to the consultation?
I have responded to the consultation. I've been told off several times for not responding to consultations, but I did get around to responding to it. Really interesting.
And bear in mind as well, Joe, that you know this firsthand, that consultation is time consuming.
Yes.
You've got to send your stage 1, your stage 2, maybe stage 3, by which point you're 4 months into this. And if you've got a project that needs to be done and needs to be done quickly, your alternative is dispensation.
Yeah.
And much as I love the tribunal, they are very overworked at the moment.
My personal view, though, is that with consultation, it just allows for a measured review by an interested leaseholder that's not subject to a sharp deadline of what can be, pretty weighty, meaty documents, I suppose. And I think probably the answer is somewhere in the middle, where things just don't just happen like that, just because three people could show up, because they always show up.
You have your budget. You have the opportunity to vote on that budget. You have a reserve fund, as Ellodie says, that's being collected. You're collecting that reserve fund in line with the PPM that you've obtained.
Yeah.
There shouldn't be the need for that snap vote and the need to suddenly get a bill for 10 grand, because you should have the reserve fund that's been collected in line with your PPM, in line with your budget that you've approved. It should level things out more. Should.
15 years from now, could we see a devaluation of leasehold properties? If Commonhold just starts to actually work in the way that we all want it to work, could you have a situation where people who, still got leasehold flats feel pretty hard done by? They were supposed to be the ones getting protected by changes in the law. We're supposed to be fighting for leaseholders, but they get kind of screwed by a change in legislation because they bought leasehold flats, and now shiny new Commonhold is the thing to have.
I think we don't know what the market is going to do, because we've not seen enough Commonhold units to be able to judge how they will be priced by the market compared to leasehold. I mean, I think from the government's point of view, they're very keen to not devalue leasehold and to make sure that there's enough going on in the leasehold reform sector to make sure that leasehold, isn't devalued. But we could equally have Commonhold is worth less than leasehold, because, as I say, what it comes down to is consumer choice. And some people might prefer to buy a Commonhold unit, but others will possibly prefer leasehold, because you can well imagine, I mean, we know working with RMCs, etc., that there are some really difficult, I mean, I certainly, from a service charge point of view, think I probably see more disputes involving resident-owned management company or, lessee-owned freehold companies than I do third-party freeholders.
Really? That's interesting.
Well, yes, because you've got everybody infighting. It's a lot easier to come together and, unite against a common enemy, and that common enemy is likely to have other properties and deep pockets. But when you're fighting your neighbours and your only asset is the freehold building, that makes it that makes it a lot more difficult. So I think, there is obviously a lot of protections in place in terms of the proposed new legislation for Commonhold, but we potentially risk having buildings that are really devalued if the Commonhold isn't well run, with problems.
So much about this sector is referred to in the context of leasehold, isn't it? You've got the Leasehold Roadshow, you've got the Leasehold London conference, very well attended. My own course, Leasehold Block Fundamentals, is called Leasehold Block Fundamentals. A lot of leasehold block managers, shall we call them, look on and worry. Are their skill sets going to be redundant? You've already given the lawyer's view, but have leasehold block managers got to be worried about Commonhold in terms of their skill sets being eroded?
They've still got to manage.
The building's still the building, isn't it?
Communal living is still a thing,
Yeah.
right?
Yeah. They just might need to, register the names of companies that involve Commonhold rather than leasehold.
Yeah, if you've not been carpetbagging that yet, then maybe that's your homework
There's some
tonight.
people who've already done it. So, anyone who's got leasehold in the title, may want to be registering a name that also involves Commonhold.
I mean, in theory, it should make it more efficient, right? That's the idea of running a block of flats, because if you've got a genuine good policy for your building, you've got a good capex plan you want to get through, you should be able to more easily get the votes recorded and get stuff legitimately done, right?
And as a manager, you've got to go to one Commonhold community statement rather than necessarily look at the leases for each individual flat to check that they are the same, or if they're not the same, check what each one says.
Probably cut down on the case law as well. Once we've had that one case decided about what this particular clause in the Commonhold community statement means, we're not rerunning that case based on what this lease might say compared to what that lease did, and is it on all fours or not?
Does that mean we're going to see less of those case law updates from you and Justin then?
I suspect not anytime soon.
Not anytime soon.
We love hearing Cass and Justin.
We'll always go to see what you have to say. I'm sure the new topic will simply be Commonhold statements and so on and so forth. Right, so I shall tell the various anxious property managers that have been asking me to ask you guys questions that they won't need new jobs anytime soon.
I don't think so.
Okay. So, moving forward, we're coming towards the end of the podcast now. Practical advice for the sector. I keep starting with you, Ellodie, so I'll start with you, Cass. How should landlords and managing agents prepare for Commonhold and leasehold reform more generally?
Yeah, I'm going to spin your question slightly, because even though I think Commonhold is very important and we've spent the last however long talking about it, I do think that there are other things coming down the track, and probably coming down the track sooner, that is going to impact property managers quicker than what Commonhold is necessarily going to impact property managers. And that's all the reforms under LAFRA, and in particular the leaseholder protection side of things under LAFRA. That is going to change.
For viewers who don't know what LAFRA is, can you spell that out for them?
Yeah, of course, a Leasehold and Freehold Reform Act. So there's lots of provisions that are in LAFRA that address that power imbalance that I mentioned earlier.
Yeah.
A lot around the transparency piece, how you're communicating, what you're communicating, and the consequences, financial consequences, if that doesn't happen. That's something that managing agents should really be focusing on and keeping a watching brief on, so that when those provisions come in, that they can respond agilely to those provisions. We had the consultation back end of last year, back end of last year, earlier this year. So we're waiting for something to happen now that that's closed.
Okay. Ellodie?
Yeah, I agree with everything Cass just said. What should managing agents be doing? I think I entirely agree with Cass that there is more that is happening that we need to get on top of now, or managing agents need to get on top of now.
Yeah.
I think it's something to be aware of. Obviously getting involved in the consultation on the draft bill with experience from the coalface is great. It's something to be aware of that what's going on, but at the moment, I don't think we should be rushing out to, learn what's in the Commonhold community statement and all this, because we don't yet have anything final. And by the time it's on the statute book and in force, it's going to be a while. And obviously, we know that property managers have got so much on their plate to deal with anyway, that I think Cass is right, that the focus for now seems to be on there's going to be some other pressing reforms that are likely to kind of demand people's attention before Commonhold really does.
Okay, thanks for that. And so, closing question then, on a sort of 5-year time frame, like if we were sat here having a podcast in 5 years' time, that's how some people are thinking about their investments, right? What does the leasehold sector look like from your point of view, Cass? What are your predictions? What will we be talking about in 5 years' time?
I hope that we're going to be talking about, rather than sat here thinking we still have a lot of buildings that haven't been remediated.
Yeah.
I hope one of the things that we will be talking about in 5 years' time is that we have a bunch of buildings that have now been remediated. That for me is a really big thing, that we are still working through our buildings that we know are unsafe, that need to be addressed.
Absolutely. Huge part of the leasehold picture. Ellodie?
I think we'll still be talking about Commonhold and and when it's coming in. No, I shouldn't say that. I'm just sort of reminded of the fact that I went to work for the Law Commission in 2018 on the basis that government wanted reforms and proposals for reforms developed in double quick time. And it took 6 years for LAFRA to get onto the statute book, and it's still not actually in force. So I think that we're probably looking, I appreciate we're a little bit further on in terms of Commonhold, because we do have Commonhold on the statute books already. We've now got a draft bill, but I think in terms of actually bringing it to fruition and it making a difference as well to developments, because bearing in mind for your large-scale developments, they're going to take more than 5 years to come on board. Now, I know that, there's going to be a sort of at the point of delivery, this is how you're selling, but I suspect in 5 years we might actually be having a more interesting conversation in which we are trying to get to grips with a new form of tenure that actually exists. But I'm not sure that we're going to be, oh yeah, Commonhold, that old thing. I think it's going to be new in 5 years' time, if at all.
Brilliant predictions there, guys. Really valuable for the viewers. That brings us to the end of our little chat.
Thank you.
Thanks for joining me today on the Block Coach podcast. Look forward to seeing you again soon. To our viewers, I would just like to remind you that today's podcast episode was sponsored by Head Start Consulting, one of the best health and safety consultants I've worked with in recent times. Do check them out if you're in need of advice about health and safety for your blocks of flats. I'm Joe Mallon, founder of the Block Coach, and that has been the end of Leasehold? See you next time.